charged with driving under the influence in Florida, in terms of criminal proceedings, the first thing that's going to happen is the state attorney's office in the county in which your charge is stemming from is going to make a determination on whether this is a misdemeanor DUI or a felony DUI, or if there are other felony charges that are associated with the DUI. And that's going to determine whether or not you're going to end up in county court or circuit court. So what will typically happen in most jurisdictions is once they make that determination, your case will be set for what's called arraignment. Arraignment is your first opportunity to do something in the case. And there's a lot of legal things that are triggered with arraignment, but effectively it's, are you going to enter a plea of no contest or guilty to the charge, or are you going to enter a plea of not guilty and then avail yourself of the discovery process and any other legal remedies in the case. On DUI cases, most people do enter a plea of not guilty at arraignment, and at that time, if you have private counsel, your attorney will be the counsel of record and begin the process of accumulating all the evidence in the case. So written reports, dash cams, body cams, traffic cameras, anything else that might exist in the case. And if you cannot afford an attorney, the court will appoint a public defender to represent you if they have not already been appointed at that arraignment. At that point, depending on what county you're in Florida, there are different names of where your case will go from there. It can be set for what's called case management. It can be set for a disposition date. It can be set for a pretrial conference. A lot of times it means the same thing, but again, the terminology can differ from county to county, which is why it's important to talk to a local attorney about your particular case. At that point, again, it's going to be going through what can be done. What is the evidence in my case? Now, the analogy I use with clients is if you think about your DUI case as a hand of cards, say poker or Uno or any card game you've ever played, the state attorney's office must play their hand face up. So because they're going to do that, because they have to, why not review everything? So you will be entitled to review their police reports, written reports, the police officer's training jacket if it applies, Florida Department of Law Enforcement, if you provided a breath sample, has this machine been calibrated? What are the records of other breath tests on this machine for the last month, for the last year? Are there any dash cams? Are there any body cams? Is there audio? Is there anything else that's in the custody of the state that they intend to use against me at a trial and I want to review it? Whether you should go to trial or not, whether you should take a plea or not, whether a trial is a bad idea and the state's not, that's beyond the scope of this video. Every DUI case is a little bit different. No video could possibly contemplate every possibility in every unique circumstance. Do talk to an experienced attorney who has handled DUI cases, and if you're deciding between lawyers, have that lawyer show you how many DUI cases have they done, how many DUI trials have they done. If they just, oh, I've done DUIs before, well, have they done 3 or have they done hundreds? When's the last time they went to trial on a DUI case? What was the verdict? If you've done enough DUI trials as a DUI attorney, you've lost some DUI trials, so nobody's won them all. But you want to make sure that the person's not afraid to go to trial and understands what a trial entails, what the risks are, what the benefits are, what can be done, what is their experience, how comfortable are they presenting this evidence. Because an attorney who's not afraid to go to trial can also be effective in negotiation because the state attorney's office is aware that that person's not simply making an empty threat. I know of people that I'm just going to set that for trial and they haven't been to trial in 5 years on a DUI. And that's sort of an empty threat that's not going to go very well when they're trying to negotiate a resolution that's best for the person individually. So again, whether the case it's going to stay in county or circuit court can also make a big difference on how long it will take the case to resolve. In my experience, DUI cases in county court depends on the judge a great deal, but it's usually resolved in 3 to 12 months. 12 months being on the long side, and certainly cases can take much longer if there's evidentiary problems. 3 months would usually be on the quick side. That's a quick turnaround in getting the evidence, getting a resolution in place. In circuit court, it seems to move a little bit quicker, only because a DUI that's in circuit court, if it's just the DUI or if it's attached, often there are far more severe cases in circuit court than a DUI, a felony DUI. So the judges are typically not going to give you as much time unless you, again, have a legitimate reason. If you're trying to get certain evidence, certain things reviewed. But if you're simply continuing the case for the sake of continuing it, you'll find it's much more difficult to do that in circuit court in Florida than county court, depending on the jurisdiction. And again, this is just coming from my experience in the Tampa Bay area. Once you receive once you reach a resolution in your case, if that's negotiated with the state, you'll just set the case for a change of plea. If you're setting up for trial, you'll set up for trial. So again, when it comes to legal proceedings, this is where a lawyer can be very helpful to help explain to you what the next step in the process is, what it entails, and if there are multiple options on where to take your case, what are the pros and cons with each option, what are your risks and rewards for each option. And again, all DUI cases, again, there are thousands of DUIs every year in Florida, but each one has unique circumstances, including the basis of the stop, who's the officer, which state attorney's office is it. So my office is in Hillsborough County. I happen to live in Pinellas County, and I can tell you from experience the difference between dealing with the Pinellas County State Attorney's Office and the Hillsborough County State Attorney's Office, especially on a first-time DUI, is very different. So while the law is the same, while the jury instructions would be the same, how those individual offices process DUIs, how amenable they are to reducing those DUIs, and what kind of first offender programs they have are very different. And that comes from the elected state attorney. There are 67 counties in Florida belonging to different judicial circuits, and each county belongs to a circuit where there's an elected state attorney, and that person really sets the tone on how a DUI case can be resolved. And I'm simply sharing that because some people will say, well, my buddy got a DUI and this time this is what happened to him. Well, that's great. But if that's not the same circuit you're in, then he may have qualified for something else. He may have had a different prosecutor's office somewhere else. They may take them less seriously or more seriously depending on where you are. So again, it's important to talk to an attorney, an experienced attorney in your area to help guide you through the process.